Every startup that wants to raise money has to be a Delaware C Corporation. It's not a recommendation, it's a hard requirement. And if you ignore it, you'll either lose the deal or pay thousands in legal fees fixing it later. But almost no one explains the actual reasoning behind why this structure exists in the first place. Now, I've personally set up hundreds of Delaware C Corps myself as a founder and as a startup lawyer. So today I'm walking you through why this is the standard so you can get your incorporation right the first time. Let's get into it. Why investors require Delaware? The Delaware question comes down to one thing, and that's predictable law. Delaware has over 200 years of case law built up specifically around business disputes, meaning when a legal issue comes up with your company, there's already a playbook for how it gets resolved. And that predictability is exactly what investors want because they don't want to bet on a judge making up new rules with their money on the line. Founders ask me all the time about Wyoming, Texas, Florida, Nevada, because they heard those states are business friendly. But the problem is business friendly usually means low fees and easy filing, not the kind of legal track record you actually need when something goes wrong at your company. Wyoming, for example, has a fraction of the corporate case law Delaware has built up, so the moment your startup hits a serious legal question, your lawyer is essentially guessing at how a Wyoming judge would rule. That uncertainty is exactly what investors are trying to avoid when they require Delaware. But the problem is business-friendly marketing and business-friendly case law are two very different things. Wyoming, for example, is mostly known for farmland, so a lot of the judges there are dealing with things like farm disputes and software company shareholder agreements. And that's a completely different level of sophistication from what your startup actually needs. Then there's the investor's familiarity side of it, which is the other part of why investors push for Delaware. VCs have seen thousands of Delaware C Corps, and their lawyers are familiar with this structure too. So investors don't want to take unnecessary risk on an unfamiliar structure when Delaware is already the gold standard. Put those two things together, legal predictability plus investor familiarity, and that's why no VC is going to choose something that's not Delaware. Now, I always tell founders it's not impossible to find investors that'll invest in your company if it's formed in your home state and not Delaware, but the pool of investors who are willing to invest decreases and shrinks. Traditional VCs only invest in Delaware C Corps, and accelerators will only accept you if you are a Delaware C Corp. Why investors require a C Corp? Now, the Delaware part of this is only half of it because a corporation is a completely separate decision from the state that you incorporate in. A lot of founders conflate the two things, but they're completely separate requirements. You could have a perfectly incorporated Delaware LLC and still no VC will invest in you because the problem isn't the state, it's the type of entity. The first reason investors won't invest in LLCs is because of a tax problem called UBTI. UBTI stands for Unrelated Business Taxable Income, and it's the reason most VC funds aren't allowed to invest in an LLC in the first place. The way it works is that VC funds raise a lot of their money from pension funds, which are tax exempt, meaning they don't pay federal taxes on their investment returns. But LLCs are what's called a pass-through entity. So any tax the LLC creates gets passed up to whoever invested in it, which in this case means the VC fund and the pension funds behind it. So the VC ends up creating a tax bill for the exact people they promised wouldn't have one, and that's why their fund documents block them from investing in LLCs to begin with. The second reason comes down to how stock works, because C Corps can issue the exact kind of stock investors want and LLCs can't. Investors want preferred stock with specific rights attached to it, things like liquidation preferences, anti-dilution protections, and dividend rights. A C Corp can create preferred stock, common stock, and multiple classes stacked on top of each other with different rights for each class of stock. An LLC doesn't have that same flexibility, so even if the tax problem didn't exist, investors still couldn't get the structure they need. Lastly, the third reason is employee equity, because the way you compensate your team long-term runs through stock options. C Corps can issue incentive stock options to employees, non-qualified stock options to advisors and contractors, and restricted stock to founders. Each of these tools has different tax treatment for the recipient and different strategic uses. Now, LLCs are much more limited in how they can distribute equity to a team, so the tools you have to recruit and retain talent are more limited. With LLCs, you have to use profits interest or phantom equity, which are just not well known by people in terms of how they work, and that lack of knowledge can work against you. Everybody knows or thinks that stock in a company is good. Most people are familiar with stock as a form of equity, whereas profit interests or phantom equity can be confusing and convoluted for employees. By the way, if you're setting up your startup, maybe for fundraising, and you want to make sure your incorporation is done right, click the first link in the description and book a free consultation with me. Now let's keep going. The QSBS tax benefit. Everything I've talked about so far is why investors want a C Corp, but there's one reason why you yourself are also going to want a C Corp, and it's called QSBS. QSBS stands for Qualified Small Business Stock, and it's one of the biggest tax benefits available to a startup founder. If you hold your founder's stock in a C Corp for 5 years, you can exclude up to $15 million in capital gains from federal taxes when you exit. That's potentially millions of dollars you get to keep instead of sending to the IRS. Now, those 5 years start counting from the day your shares are issued, which is another reason to get this done early. A founder who incorporates and issues stock on day one is 5 years closer to that exclusion than a founder who waits. And QSBS only applies to C Corps, which means it's one part of the structure that actually protects your personal upside as a founder. Everything else in a C Corp is really there for the investors, but this is the one thing working in your favor as the person who built the company. So even if you found an investor who is willing to fund your LLC, you'd be giving up a 7-figure or 8-figure tax break to do it. One founder didn't use a startup lawyer when they started their software company, and they started as an LLC by the recommendation of the lawyer. And when they got acquired, they only learned about QSBS after they were acquired, and they realized that they paid millions of dollars in taxes that they didn't need to because they used a lawyer that wasn't a startup lawyer. And they say it's one of their biggest regrets and learning lessons. Don't let that happen to you. What happens when founders get this wrong? Now, the most common mistake I see is founders who try to save a few $100s by starting as an LLC in their home state, thinking they'll just convert later if they need to. But the problem is converting later costs way more than getting it right from the start. A conversion from an LLC to a Delaware C Corp typically runs around $5,000 in legal fees, assuming the company is clean. If the company has a lot of history already, vendor contracts, early employment agreements, maybe some IP questions, it can be more expensive because your lawyer has to sort through all of it. One client of mine actually went through 3 separate conversions before getting it right. He started as a Pennsylvania LLC, then he heard he needed to incorporate as a C Corp, so he converted to a Pennsylvania corporation. After that, he talked to investors and they told him he needed to be a Delaware corporation, so he converted again from a Pennsylvania corporation to a Delaware corporation. So he had 3 conversions, 3 sets of legal fees, which could have just been completely avoided if he'd started as a Delaware C Corp from day one and worked with a startup lawyer who knew what they were doing. The other part to think about is when the conversion actually happens in the fundraising timeline. Usually founders rush to convert right around the term sheet stage, which is the worst possible time because you're in active conversations with an investor, you're trying to move fast, and suddenly you have to pause your deal to convert your entity, file in your home state, file in Delaware, and set up a new bank account because your LLC no longer exists. All of that delay can cost you your deal because investors get nervous when a raise slows down and they start looking at the next opportunity in their pipeline. There's also one more filing you have to get right once you're operating in your home state as a Delaware corporation. You need to file what's called a foreign registration statement with your home state's Secretary of State. If you skip it, you can lose your limited liability protection, meaning you can get sued personally for company debts and you can face fines on top of that. So if you're starting a company and you want to get incorporation right the first time, or if you're already operating as an LLC and you want to convert before an investor forces you to, click the first link in the description and book a free consultation with me. I'll look at where you're at right now, walk you through exactly what you need, and handle the paperwork so it's done right from day one. Again, you can book a free consultation with me by clicking the first link below this video. And if you want to know when you should hire a lawyer for your startup, then check out this video next.